Pay that worker deferred to flexible spending account does not count as wages in determining unemployment eligibility. Claudia Bernard v. Unemployment Compensation Review Commission et al. Case number 2012-0717, 2nd District Court of Appeals, Miami County.
Your Honor, the claimant specifically proposed this FSA and cafeteria plan to the employer. She went and consulted an outside accountant, did all the homework on the plan, and then brought it to the employer and said, this is how I want to be paid so I can keep my taxable wages low.
So she sets that money aside, and if she doesn't use it for, or if she doesn't have reimbursable amounts up to $9,000, she never gets that money. So it's never given to her for her use, correct?
That is my understanding, yes. And I see that I am.
How could she sacrifice her if she earned it? How could that make sense that she never is able to, how would this whole scheme make any sense?
Your Honor, I leave that to the federal legislature. This was a scheme, and I see that I am over my time.
Yes, go ahead and answer.
The scheme was put in place, as my understanding, to promote the ability of individuals to place money in a tax-deferred or non-taxable account in order to pay medical expenses. And that is what was done in this case.
I took it out of the taxation scheme so I didn't have to pay a tax, but when it comes time to collecting unemployment tax, I do get the benefit of having paid in. Is that correct?
That's certainly right. Just one thing that I would adjust about that the unemployment tax is something that's paid by the employer. Now here, it was not paid by the employer because FSA payments, money that's segregated into an FSA, is not taxed for the employer paying their share of the tax. So there's no inflow to match the outflow. But directly to your question, it is true that what Bernard is seeking to do here is to characterize the money in two different ways at two different times. When it came time to ask to put it in the flexible spending arrangement, she said, take this $10,800, and that's the amount, it's $900 per month, adds up to $10,800. She said, take that $10,800 and treat it as non-income, non-wages. I don't pay federal income tax on it. I don't pay FICA tax on it. Then, as the trial court put it bluntly in the last footnote of its opinion, she wants now, when it comes time for unemployment compensation purposes, to say, now treat it as income. And that's not what the plain text of the statutes tell us.
The Ohio Supreme Court ruled on July 25, 2013, that earnings deposited into a flexible spending account for reimbursement of medical costs under an employer's cafeteria plan do not qualify as remuneration to determine an employee's unemployment compensation eligibility. Written by Justice Judith Ann Lansinger, the Supreme Court's ruling affirmed a decision by the 2nd District Court of Appeals. Joining Justice Lansinger in the lead opinion were Chief Justice Maureen O'Connor and Justice Judith L. French. Justice Terrence O'Donnell concurred in judgment only. Justice Sharon L. Kennedy wrote a concurring opinion which was joined by Justice O'Donnell, in which she agreed that the taxable remuneration statutes are not ambiguous. Justice Paul E. Pfeiffer wrote a dissent. Justice William M. O'Neill dissented without opinion.